Number 134, matter of statewide coalition of Hispanic Chambers of Commerce versus the New York City Department of Health. Counselor, would you like any rebuttal time?
Yes, may I reserve 3 minutes for rebuttal, please?
3 minutes, sure. Go ahead, you're on.
May it please the Court, I'm Richard Deering for the City Board of Health, the Department of Health, and its Commissioner. The rule here does not ban sugary drinks, and it does not dictate consumption choices or amounts of consumption.
Counsel, what legislative, and I put that in quotes, powers does the board have?
The board has plenary legislative powers in the area of public health.
What does that mean? Do they replace the legislature, the city council, in relation to public health? What is the relationship between that plenary legislative power and the powers of the city council and the powers of the New York State legislature?
The board is subsidiary to the New York State legislature, and the New York State legislature can overrule any measure that the board passes.
Could the city council amend the city charter to narrow the board's powers?
The city council could not, because it would raise a curtailment problem. There are a variety of methods through which the charter could be amended, but a direct city council amendment.
Could they overrule the Board of Health in the particular areas that we're talking about today?
Our position is that they may not. We recognize it's a question this Court has not yet had to confront. That question is not presented in this case. The only question that's presented in this case is whether a specific legislative authorization from the city council or the state legislature was required before the board could pass this rule.
Do dietary choices fall under the ambit of public health?
The presentation of products that raise serious health risks fall under the ambit of public health within the restaurant system of New York that has long been regulated by the Board of Health.
They could ban sugary drinks if they wanted to.
On this record, I don't think they could ban it, and that's a key point.
Because it would be arbitrary and capricious?
Because it would be yes, Your Honor, because it would be a response that's not appropriate for the nature of the risk. And
but if they made a record that showed that it was appropriate, they could.
That's correct.
What's the nature of the risk?
The nature of the risk stems from overconsumption. That's what the vast...
Is it a crisis of epidemic proportions?
Obesity is certainly a crisis of epidemic proportions, and there's a vast...
New York City, is there a crisis of epidemic proportions now in relation to obesity and the consumption of non-nutritious sugary drinks?
There's a serious crisis as to obesity in New York City. And there is a rich, vast, and growing body of literature that shows that sugary drinks, overconsumption of sugary drinks, plays a unique role.
Do you see a limit on what you can do? Where would you draw the line on what you could not do?
The measure has to be related to public health. It has to be...
Well, no, but I mean, I think Burger King has triple burgers. Can you say you can only have one?
Not on this record.
No, I'm just saying, you say you're a legislative body, and that you have chronic, you have jurisdiction over all chronic diseases, and obesity is one. So just like now, you say, well, this drink's too big, we're going to make them smaller. And you say these hamburgers, there's too many patties in this, so the Big Mac has to go.
I think that a regulation like that would raise different questions as to whether it is arbitrary or capricious.
Forget that. I'm just saying, could you? In other words, you say these people are obese. The fast food industry is doing it. We've got studies that say 3 hamburgers are worse than 2 or 1, and so we're going to say that you can only put 1 hamburger in a roll. You at least, in theory, believe you have that power. Assuming you could. In theory,
but it would depend critically on the record, the scientific record that is compiled, and whether the step taken is appropriate in light of the scientific.
You say you could do anything. You could do anything a legislature could do. The state legislature can overrule you, but you could do anything they could do as long as they haven't overruled you.
That's right, and as long as it's not otherwise preempted, as long as it doesn't range into matters that are specifically committed to other bodies.
So what was the scientific record that led to the determination as to the size and what types of products here would be restricted? Because certainly there's coffee drinks that are over 800 calories.
Right, and we don't know.
There's all kinds of these specialty coffee drinks that would have as much, if not more, calories than the types of sugar drinks that you aim this at. So how is this not arbitrary?
Yeah, Your Honor, we don't know as we sit here where any particular coffee drink falls with respect to this rule. This rule is drawn based on the scientific record that...
Yeah, but I think what the judge is asking you, what's the reasonableness of what you didn't address, and you did address this particular negative impact on the health? What about coffee products, alcohol, where these drinks are sold? What's reasonable about the framework that you've put together that is being, in effect, banned in
Well, alcohol is preempted, so we put that to one side. But let's talk about three key elements of
Why
this.
these choices? I guess that's what we're asking.
That's right. Three key elements. Number one, sugary drinks, the largest source of added sugar in the American diet. 40% of added sugar comes from sugary drinks. Two, they're empty calories, meaning they don't provide nutritional value. And three, they're not filling. And what that means is that when you consume calories via sugary drinks, you don't reduce other caloric consumption.
Are those scientific facts?
They are. They're well established in the
It's
literature.
not filling? Yeah.
They have been proven in multiple studies. All of the science is laid out in Dr. Farley's affidavit.
So anything that's you could scientifically prove is not nutritious, the board, and again, I'm not leading you in any direction, the board could say, not nutritious, people get hurt because of it, we're going to ban it, whatever it might be. If the hamburger analogy that Judge Pickett gave you, if there's a study that says, you know, those hamburgers are not only bad for you, there's not one good thing we can think of that comes from them, you could ban the triple deckers, all three patties, couldn't you?
Well, we know hamburgers have protein. We know they're filling, and it's not about.
But let's say there was a study or enough studies that show that they really, whatever they do for you is way counteracted by what's bad for you. Couldn't you ban hamburgers altogether from New York City, or could you?
I can't really address what could be done on a hypothetical.
Yeah, but I'm
The key is
asking.
this
I'm
record.
asking you if you had the scientific evidence that said overwhelmingly the hamburgers, even if they have some protein in it, overwhelmingly they hurt you terribly. Isn't there a reasonable framework that's within the scope of your powers that you could imagine that would say no more hamburgers in New York City, or they might be hot dogs or whatever it might be? Why can't you do that in the hypothetical situation where you had the scientific evidence to back that up?
If we had the scientific evidence to show that they were a unique and serious contributor to we could take an appropriate step.
Suppose you have scientific evidence that says that beef is a lot worse for you than chicken. I'll bet you could get a lot of scientific evidence that says cholesterol is really bad for you. Can you say, okay, all New York City restaurants serve only chicken, no more beef?
No.
Why not?
And that's not, Your Honor, because to ban a product, and this I think is really where the appellate division...
And there are a lot of harm. I mean, cholesterol does a lot of harm. There are a lot of heart attacks in New York City.
This is not a ban. To ban
I
a product...
understand.
To ban a product, the appellate division talked about things in terms of health hazard per se or inherently harmful. To ban a product, I'd submit, it's not enough to say something else out there is better for you. You have to show the product itself is unsafe. And that test wouldn't be met in that case.
Counsel, where do you draw the line? These kind of hypotheticals that we're giving to you, how is it distinguished from this particular ban or whatever you want to call it that's been put in place by the Department of Health? Where do we say it's okay as opposed to banning hamburgers or meat or frankfurters or whatever it might be? How do we know what's okay?
First of all, bans go in a completely different category. This is not a ban. What we're talking about...
What is it?
It's a limitation on container size. Any individual can consume as much as they want. It has to be presented to them in 16-ounce containers, and it's designed to... It's like a warning label.
So you're banning that size, but go ahead.
It's like a warning label. It's designed to prompt a conscious choice by the consumer.
Can you limit portion size of any other? So we could say that steaks should be no more than 12 ounces?
Or
Your
French
Honor,
fries?
it would depend on the record. The thing that distinguishes sugary drinks is the overwhelming scientific evidence.
I think the thing that troubles at least me, and I think the others, is we don't know where this ends. It seems like in your brief and in the record that you're arguing there's a separate legislature in the city of New York. It's not the elected one, it's the appointed one, and it's us, and we're smart, and we get to decide all of this, and the city council has nothing to say about it, the mayor has nothing to say about it, and if we want to decide that M&Ms are bad for you and that store's got to close down in Times Square, we can do it.
It's not nothing to say, and I think that's the key point. The key point about the board, it is a body of experts dedicated to public health, and it is able to act autonomously, as this court has held again and again and again, without particularized prior legislative authorization.
But again, where is the line? You have documentaries recently, not to be hamburger-centric, that say that supersizing, the supersized French fries are a disaster for everybody. These places, the fast food places, are supersizing everything, and they're killing people. Can you, if there's some scientific evidence, a lot of scientific evidence, a little scientific evidence to back that up, and this documentary goes viral and everyone sees, does the Board of Health the next month or the next year say, you know what, supersizing is killing people. There's an epidemic in our city. We're banning that supersize. That's a similar thing to banning a certain size container. That's a good analogy, right? In your
it has similarities. It would depend on the strength of the record, and if the record there was a record comparable to the record here that a particularized and special and serious health risk was presented, then a reduction in size of the product subject to an individual's ability to order as many as they want.
That's the rule, that we have to look at the record as opposed to any other framework that we should look at.
The framework is
the Boreali framework. We shouldn't look at that at all.
The Boreali framework doesn't apply because that's a state legislature, state agency framework. The rule is arbitrary and capriciousness. That would be the standard. It does not mean that the board operates outside.
Since when is arbitrary and capricious the standard for a legislature? I thought it was a rational basis.
Your Honor, in the Grossman case, you said, when you're talking about this board, a statute or administrative regulation legislative in nature needs to be rational and not arbitrary and capricious. That's really where I'm drawing
What's
the
the rational basis? I'm going to move to a different subject now. What's the rational basis for the vendors that are subject to this portion restriction?
They are the vendors.
Because the board didn't decide that any entity that sells sugary drinks is going to be subject to this.
The rule is written in those terms, as the petitioners themselves acknowledge on page 12 of their brief, as is the entirety of Article 81 of the Health Code. The board has determined, based on its interpretation of this memorandum of understanding between two state agencies, that the state has reserved for itself enforcement jurisdiction as to marked groceries or similar markets.
And you can walk into a grocery store and buy a 2-liter bottle of some kind of cola drink.
That's right,
correct?
and the board can't enforce its rule against.
You can't do that if you stop at a fast food.
It's true, and it's because of the memorandum of understanding that reserves to the state enforcement as to those entities and gives the city authority over.
So what was the basis for making those distinctions as vendor? Why is that not irrational?
Because the distinction is entirely based on an interpretation of that memorandum of understanding entered into by state agencies, including the Department of Health, that has supervisory authority over the city department.
Even though you're allowed, there's one question I want to get you to address if I can. You say you're a legislature, and that you're the same. Let's suppose we disagree with you on that. Suppose we say you're an administrative agency just like everybody else, and the Boreali analysis does apply. You still win?
We still win.
Why
in
a minimum number of votes?
Yeah, I'll do my best to do it quickly. I still think you got to go to the case law of the Board of Health. It's been upheld again and again and again, acting without particularized legislative authorization. But let's look at Boreali. The basic question in Boreali is, have you usurped legislative power when you're acting as an administrative agency? The question is, what about this is a usurpation of legislative power? We have the first question is, what is the category of products that we cover? That's based entirely on scientific evidence, as is documented in Commissioner Farley's affidavit. It's clearly within the domain of the Board of Health as an expert body. The second question is, what is the measure that is taken? It is a modest measure. It is a limitation on container size, no hard limit on consumption, no ban, nothing comparable.
Have you ever limited portion size before in any context?
I'm not aware of it, but there's always a first time, and it is specifically based on a health risk that the scientific evidence has documented.
You're
it
saying
is pressing.
you have greater you have greater rulemaking authority than the State Department of Health, or do you distinguish Boreali because that was more in the nature of a total ban as opposed to what you did here?
Both are true.
Explain to me how you distinguish.
No, both are true. We have the City Board of Health's powers as recognized by, there's no comparable record as to the Public Health Council, which passed the regulation at issue in Boreali, that there is for the City Board of Health.
I'm sure they had pretty substantial medical evidence that smoking was detrimental to health.
I'm talking now about the legal record affirming the plenary breadth of the agency's powers. But even under Boreali, I do think the difference between a ban, the intrusiveness and sweeping nature of what the agency did in Boreali, including applying to every employer in the state of New York, almost every commercial retailer in the state of New York, a host of entities that agency had never regulated before. That's Boreali's regulation. Our regulation is a modest, science-based, and narrowly drawn regulation.
Okay, you'll have your rebuttal. Let's hear from your adversary.
May it please the Court. I'm Richard Bress, and I represent the plaintiff's respondents in this case.
Counsel, you have a body that clearly has plenary legislative power. You do have a documented health crisis in New York. They're not doing a widespread ban. They're taking a incremental, measured approach. Why isn't this within the scope of their power, and why isn't it reasonable the way they framed it, particularly when in other areas of health, I think we would all not challenge whether it be fluoride with the water or trans fats or whatever the issue. Why isn't this along those lines of a reasonable, measured approach within their recognized and with many precedents over many years and done in a reasonable, rational fashion? What's wrong with what they did?
Well, Your Honor, I think there were three questions within that. One was
Go
the premise that they have plenary legislative power.
Okay.
We obviously disagree with that. Happy to address it. Number two, that they exercised it in a way that was within the authority that's been given to them. And the third was that it was reasonable, Your Honor.
Okay, start with the legislative power. You don't think they have plenary legislative power?
Absolutely
That's kind of unique in our governmental?
Absolutely not, Your
What
Honor.
do they have?
What they've got.
What is their power?
Your Honor, they are an administrative agency within the executive branch in New York City.
Period.
Has that always been the case? Has it always been, have the different changes to the city charter over the years altered their status?
I don't think so, Your Honor, but if you were going to point, I don't think they ever had plenary power, Your Honor, but if you were going to pick a demarcation point, certainly never since the 1937 charter, the Home Rule Charter. And it's awfully clear, by the way, from the Constitution on through the municipal home rule law, on through the city charter. So you start with the Constitution. The Constitution provides that every local body will have an elective legislative branch. They're not elective. You move on to the municipal home rule law. It provides that local laws are passed either by legislatures or by referenda, not by agencies.
You don't deny that they are expert in what they do and that they do have wide powers, however you characterize them, in terms of addressing health issues in New York City. That you would accept.
We will accept that they've got the same sort of authority that the PHC has at the state level. No question about it. But when you get to the city charter, the city charter says that the city council is the legislative body, that the legislative power belongs to them. It classifies specifically in CAPA the board and other agencies as executive agencies.
What if we didn't characterize it as what they did as legislative? What if we said it's a regulation? Assume your terminology, that they're an administrative entity and they issue the regulation within the scope of their power, and assume that it's rational. What's wrong with that?
Absolutely, Your Honor. I think that one way of looking at it would be to compare this case to Boreali at the invitation of my brother. So Boreali was a case that involved a regulation that was far closer to the line of lawful than this one. Boreali involved an agency.
You don't think Boreali was more intrusive and more a wide spectrum of what they were doing and ventured more into the policy arena, even in this?
Not at all, Your Honor, because
Go ahead.
what I'm talking about here is the difference between that the two circumstances bring between what the agency was doing in terms of the role of government in people's lives. So in Borealis, you had a circumstance where what was being regulated was toxins, carcinogens, being put into the air that harmed third parties. The dissent in that case, mind you, in Borealis, noted that if instead...
You're saying that that in this case they're protecting people from themselves, not from other people, but the Department of Health is always protecting people from themselves.
They've protected people from themselves, Your Honor, in circumstances where you're dealing with sanitation, when you're dealing with infectious diseases, and those are all powers that they've had very expressly under the Charter.
What about window guards? Don't they require that window guards be placed in?
Yes, and they had specific authority within the Charter and within Title 17 to protect people from accidents. That was again an express power. So if you look at the...
Didn't they do calorie counts?
They did calorie counts, Your Honor, which are akin to misbranding types of regulations and labeling. These are, again, traditional health regulations.
It's because you know, they're there, and I guess you like them. But I mean, what's the big deal about saying you're going to buy your pop, you got to buy it in a smaller cup?
Your Honor, the difference is for the very first time, a government body here, the board, has taken it onto itself to have government intrude in a way into people's personal decisions here, how much you want to eat, what you want to eat,
What about
in ways that it hasn't.
fluoride in your water?
Fluoride in your water wasn't your water, of course, Your Honor. We're talking about the city's water, and there was an express authorization with regard to the wholesomeness of the city water. What you didn't have there was a...
What were they supposed to do? Were they supposed to take this record of scientific evidence to the city council and ask the city council to pass legislation?
Absolutely, Your Honor. That's exactly what happened in Borealis.
Then you wouldn't have cared. Then you'd say this is okay.
Well, Your Honor, as a political matter, we would have exercised all of our rights that we ordinarily have.
There were public hearings here. There was, there were studies. There were a lot of things.
Your Honor, what we didn't have is the will of the people. And what this Court said in Blanchard was that the sovereign lawmaking power of the people belongs to the legislature, not to administrative agencies. So if government is going to make a sea change in how it regulates...
But what's such a sea change? You could still drink soda.
Your Honor, they are
You buy it in a different package, or smaller or larger or whatever. Not telling people they can't have it.
Your Honor, what they're telling a mother who wants to order pizza with a 2-liter bottle for her family is that she can't have it. What they're telling someone who wants a...
There's not as much of an economic impact here as an outright ban would be.
Absolutely, Your Honor.
Somebody can still buy 2 or 3 containers of soda if they want to and get the same total ounces.
Agreed. The board is banking on the fact that by making it more inconvenient, they call it the hassle factor on page 1423, they will, in a sense, use government coercion to convince people not to. They call it informational.
They do that, for example, with gasoline cans. You can't buy gas for your lawnmower in more than a 2.5-gallon can. Now, that may be aggravating if you got a big lawn, but everybody says it's safer and all this other stuff, and so you do it. What's the big deal?
Your Honor, when it comes to food regulation, which is the claim that they're making in this case, no governmental body has overstepped the bounds and told us what portions we can have. And if I may, I believe that the board is running away.
Anything to do with portions they can't do.
Not just portions. They can't ban the products, Your Honor. When we're talking about...
What if they say that you can't sell only a small amount, you got to make it bigger rather than make it smaller? Why is it such a great, terrible government intrusion to make some regulations about how you package food?
Your Honor, we're not talking about great and terrible. What we're talking about is inserting government...
It's not so great and terrible. Why isn't it okay?
No, Your Honor, the mayor himself and the board, when they announced this, didn't say this is a small and modest science-based change. What they said is this is historic. They said this is groundbreaking. They said it's a bold new policy. And, in fact, what they said on page...
Yeah, but a bold new policy can be incremental in nature.
Your Honor, on page 1429 of the record, when in their response to comments, what they said is that this brings to bear the question of the appropriate role of government in our lives, just like any other innovative policy like smoking. They're the ones that said that. On page 1479 and 1480, the board members noted that this brings up the question of what makes us Americans the right to choose. And what I'm getting at here, Your Honor, is the decision in and of itself to insert the government into what we eat and how much
Counsel,
we
the
eat.
government is involved in our lives in so many different ways, and there are different views as to how far the government can go.
I agree.
But clearly, that the government is a factor in our lives, in our everyday lives, is not open to discussion
Absolutely,
in the year
Your Honor.
2014.
But what this Court has said over and over and over again is that the basic policy choices, those with profound economic and social significance, are made by the legislature, and it's to the agencies.
No, you're saying the legislature can decide how far the government inserts
Yes.
itself. Suppose the legislature had said, we think that overconsumption of sugary drinks is a problem, and we authorize the Board of Health to devise regulations to fix it, and they come up with this. Is that okay?
I don't think at that point, Your Honor, that we would have a Boreali argument.
Why
now,
not?
we would still
Why
have.
not? Boreali makes it sound as though they were transgressing a constitutional limit on delegation.
In Boreali, Your Honor, what this Court did is it presumed irrebuttably that the statute, the statutory authorization, did not allow a degree of delegation that would allow the agency to behave like a legislature. And essentially what it is, it's an interpretive principle. You look at when you're trying to figure out whether the agency has certain authority, you assume, again, irrebuttably, that the legislature did not mean to give lawmaking power to the agency.
You said even if you don't have Boreali, you have another argument?
Oh, well, certainly, Your Honor.
I just didn't want you to miss it.
Oh, no, thank you. Your Honor, in addition to the fact that they overstepped their bounds as an administrative agency, the rule is also arbitrary and capricious in three different ways. In the sense that of the establishments that it covers, doesn't even cover the home of the big gulp, in the sense of the types of products that it covers and in the way it regulates them. And if I can quickly walk through the three, Your Honor.
Why do you think they made the distinctions that they did in who it applies to or what it applies to?
Your Honor, they claim that the distinction is based on the MOU. Let me start with first principles here. First of all, they get no deference in reading the MOU. It's simply a contract between two state agencies. Number two, if you look at what the MOU is about, it's about cleanliness, it's about sanitation, and it's about misbranding. And the reason for covering those things is those are the things that the two agencies share regulatory authority for. It's not necessary.
Yeah, but isn't it rational to want to make sure that
Absolutely, Your Honor. I'm not.
That you're consistent and you're not overstepping.
Your Honor, I agree with the MOU.
Why is that?
It makes a lot of sense.
Yeah.
But here's the problem. Telling people how much soda they can drink, pizza they can eat, cheeseburgers they can eat, and mind you, all of those are within the power they're claiming. Don't let their comments about the record fool you.
Yeah, but
telling
their
people those things
hypotheticals that we're raising, their particular regulation is as to size and particular establishments, and that you could still get the item, you just can't be packaged in a certain way. What is so revolutionary? Put aside the hype about what they're doing. What's so revolutionary?
Well, the revolutionary thing about it, Your Honor, is it may be only a first step, but it is a first step over the line to telling us what portion sizes we can have. There is no difference in
So if
principle.
there are later steps, for the later steps,
No.
then the nose under the tent idea takes away from the fact we're looking at this particular relatively modest regulation, no matter how it's characterized.
And this relatively modest regulation, Your Honor, does tell us what portion sizes we can have of
So
certain
you can never
beverages.
do portion size.
Your Honor, they can't.
Is that right?
That's right. Not without legislative authority.
So the Board of Health can never make any regulations relating to portion size.
They can't tell us how many cheeseburgers or French fries we can have without.
Until the legislature says they can.
Until they're told that they can. But and Your Honor, the other distinction that is important here is important.
Can school districts restrict the sale of sugar drinks in schools?
Absolutely. They've got plenary power.
How is that different
Because
from
they have
this
specific.
board acting?
Sorry, Your Honor. They have specific statutory authorization when it comes to the care of students in schools. Similarly with daycare, there's a specific provision that allows them to inspect for appropriate care of the children in daycare.
But why
they don't have that with
why is
grown-ups.
portion size so unique as opposed to don't put trans fats when you make the French fries, so when they go into the package, they're going to be different what goes in. So here, when it goes into the package, it's going to be different. It'll be a little smaller rather than a little bigger. What's so different about it?
The difference, Your Honor, and this is an important difference, is that the policy decision as to food regulation, as to sanitation, as to contamination, all of that, has been made by the legislature. They've assigned those roles to the Board of Health. They've never told the Board of Health or any other governmental body that not only size portions, there's no difference in principle between that and
trans fats are bad for you because they kill people. This is bad for you because they kill people. That's the same theory that they're acting.
Their theory also covers cholesterol. They could eat just as the difference that we're talking about here is the difference between a regulation that tells you the proper storage and care of eggs to prevent salmonella. That they traditionally can have. The authority they don't have is to tell us that we can only have 2 eggs a day because the cholesterol is bad for us. They've got authority to prevent spoliation of meat. They don't have the authority to tell us we can only have a 4-ounce slice.
You would not say that that an agency can't make policy judgments, can they? Can an agency do cost-benefit analysis?
As this Court said in Boreali, agencies do cost-benefit analysis all the time, ordinarily with guidance from the legislature in terms of how to do that. The problem in this case is they've gone beyond. Another problem in this case is in trying to design a regulation that they claim is more modest. What they're doing is their own balancing of personal privacy and social concerns as the choice.
But the thrust of your argument, let's get it clear. The thrust of what you're saying, they can't tell you what to eat or how much to eat or drink. Is that what it is?
No, Your Honor.
Sum up your argument in a nutshell. Is it the intrusion on your lifestyle? What is it that if you had to identify one thing that's wrong with this effort, what is it?
Your Honor, what they can't do is make a policy choice that the legislature hasn't made.
Only the elected representative.
The elected representative, if government is going to get involved with questions of how much of normal healthy
So your argument is this is a policy choice that they can't make.
Exactly.
That's the heart of it. End of
That's right,
story.
Your Honor. And if I can
as opposed to trans fats or fluoride, those aren't policy choices.
Well, no, those actually, Your Honor, those fit within specific statutory delegations. This doesn't even arguably do that.
Okay,
and if I could answer just for one moment.
Answer, Judge.
You had a statute dealing with the trans fats?
I'm sorry, Your
You
Honor.
had a city council act dealing with the trans
You
fats?
did, Your Honor. So that was never put to the test. We don't actually believe that the trans fat ban was something that would have passed muster either. The trans fat ban was very much like telling people they can't have eggs because of cholesterol or you can't have red meat because of colon cancer. We don't think they had that authority on their own, but that wasn't tested.
Answer Judge Piggott's question that you wanted to address.
So, Judge Piggott, thank you. As to the MOU, nothing in the MOU speaks to this kind of regulation, so we don't think it was ever intended to be covered. Secondly, as to the MOU, the city has plenty of other regulations, including prohibitions on use of common.
Suppose the board wanted to do a less ambitious regulation, the kind that you say is ordinarily perfectly legitimate. Any problem about them applying it only to on the basis of the MOU, leaving the grocery stores out?
Your Honor, they may be able to come up with a different reason why applying it to only grocery stores makes sense. So, for example, take trans fats.
Suppose this regulation said you sell any size you want, but tell people how many calories they're getting. That's legitimate, right?
Yes, certainly.
And can they say it's only movie theaters, not grocery stores, that we're going to do?
Well, at a certain point, you would become arbitrary and capricious, Your Honor, but that's the test that you would have to look at. It wouldn't have anything to do with Boreali at that point.
Okay, counsel. Okay, I think if you answered Judge Piggott's question.
I didn't answer the other two.
Unless Judge Piggott has another question.
Sorry,
okay.
Just quickly, the other two.
No, counsel, your adversary's rebuttal. Okay, go ahead.
Just a couple points. First, Mr. Bress said.
Counsel, they say trans fats is no good also.
That's how I heard it too, Your Honor, and I think there's something in something of a contradiction. They say calorie counts is fine. They say the problem here is not, as how I understood the answer to Judge Smith's question, the problem here is that the City Council hasn't said sugar-sweetened beverages are bad. If they had said that, this portion size would be fine.
Yeah, but they say in effect, you're doing a policy area, and the people who are elected by the citizens should be the ones who determine that, not an administrative entity.
But identifying health risks and identifying them based on scientific evidence, which is what we have here, Commissioner Farley's affidavit, record 1544 to 1568, is squarely within the domain.
Their concern, I
the
think,
Board of Health.
is that you're an unruly horse, that it's unfettered. We don't know where you're going with chronic disease, and everybody can think of another place you can go, and people are saying, wait a minute, this isn't the legislature, this isn't the mayor, this is some group.
Right, I
that's
think
going to do these. And so that's why I think earlier on you were asked, what's the limit on what you can do? Is it simply chronic disease, and therefore you can ban cars because it's, the carbon monoxide?
Your Honor, that would tread far into domains.
I was doing that on purpose,
Understood.
but can you tell me where your boundary is?
The boundary is public health in New York City in matters that aren't allocated to other agencies. It can be overruled by the state legislature, and I guarantee you.
What about if you did a total ban on drinking soda? What's different from, or drinking sugary soda? What's different if it has no nutritious value, and you have this power, this legislative, whatever you want to call it, plenary power, no nutritious value, it's killing people? Why can't you just ban those sugary drinks, not just the big container?
Right.
Why can't you ban it?
I think
you do the same thing. You make certain exceptions, whatever.
Right.
You only do it in certain stores. Why can't you say you can't drink the soda? It's killing you. That's it. What's the difference between that and what you did?
The difference is that soda is not a per se health risk. It is not dangerous in small quantities. If you're going to ban something, that might be the right question to ask.
If the New York State legislature wants to ban soda, it can ban it, can't it?
It may or may not. I would not. I don't know how that case would come out.
Do you have as much power as they do? Is that what you're
Not
saying?
as much power as they do, but we
They
have.
have the power to overrule you.
Yes.
But as long as they don't overrule you, you can do anything they can do.
No, because we are constrained in
health
New York City in public health. And
But what if the scientific evidence said that small amounts of the sugary sodas kill people? They're no good for you. It's not harmless in small amounts. Can you ban it?
if that were true, we could ban it the way trans fats is banned, lead paint is severely restricted. If you hypothesize that the nature of that nature
Like
of the
the
risk,
legislature
you
could do, like the legislature could do, you could do it, right?
That would be an appropriate ban.
Can they just say this product has no nutritional value?
Can they say it?
Right. That would include more than just sugary drinks. That would include anything with artificial sweeteners as well. Can they say all soda has no nutritional value? In other words, broaden this particular restriction to include.
No. The restriction here is based on a particularized health risk that is posed by the added sugar content of sugary drinks.
Can't you come up with a particularized health risk for almost any product you can name? There's probably some for diet soda.
Nothing comparable to the record presented here. That is the record.
It's not opening a Pandora's box to
It's not
all
opening a
kinds of
Pandora's
other
box.
products.
The board has acted. It is entirely speculative and hypothetical. The board has acted reasonably. We've been in the area of anti-obesity for 10 years. We've taken appropriate steps during that period.
If you are considered an administrative body rather than a legislative body, and you did, your portions cap rule was passed by you or disseminated by you, is it your position that the city council could not legislate that and say, we don't want this portion cap?
That's our position. Whether that question is not presented.
Why wouldn't they be able to do that?
Because under the structure of the charter, the Board of Health, the area of health, the Board of Health is the paramount authority in the area of health.
As a matter of fact,
Subject.
as I read some of those old cases, the city council can't touch public health at all. You're not saying that, are you?
We're not saying that, but some of the old cases suggested. The state legislature could always step in, and if the board really ran amok, there's no historical basis to believe that will happen. The state legislature, I promise, would shut it down quickly, or the voters of the city of New York would amend the charter. In many ways, that would be stopped.
Okay. Thank you both. Appreciate it.